everyone. Welcome to 4 Questions Friday. I literally just made that up. 4 Questions Friday. Because it's Friday and I want to answer 4 questions about immigration, family-based, different kinds of questions I've gotten over the week, hoping that someone will benefit from the answers. You know how in school when, the teacher is like, no question is a stupid question because one question you're thinking about, somebody else most likely is thinking the same thing, even though they don't raise their hands to ask. So these people raise their hands. I'm going to read the questions. I'll provide an answer. Hopefully it'll lead to a discussion about the area that I'm talking about. So stay tuned. All right, first question. My brother lives overseas, and I would like to file for his family-based immigration. I would like to know if I could file for his wife and 2 kids as well. I mean, as part of the same application. If not, what is the procedure to help his wife and kids also immigrate with him? Okay. So I think this person is asking, I am a U.S. citizen and I want to help my brother who lives outside of the U.S. to come into the U.S. And while I'm doing that, can I help my brother's wife and his children? So there's a couple of answers, a couple of things going on in this question. So I'm going to try to break it down from the beginning. So first of all, yes, the sibling of a U.S. citizen can definitely acquire immigration benefits, that is a green card, through their siblings. However, the first question you want to find out is what country overseas is this person from? This matters because if you're from a country like Nigeria or Sudan or something like that, your country may be on the list, the ban list for immigrant visas. So first of all, you have to find out, am I from a country where immigrant visas are banned? Immigrant visas meaning green cards and stuff like that. So if you're not from that kind of country, you're from a country, let's say Morocco, where immigrant visas aren't banned. So yes, and you have a brother in Morocco and you want to apply for him to get his green card, definitely you can do that. Now, to file for his wife and children is a separate thing. His wife and children are something called derivative applicants. This means that they will be able to acquire their green card by reason of being married to your brother. So yes, you can file for your brother. You can file directly for his wife and 2 children, but in his application, he can definitely add his wife and his 2 children as derivative applicants, and then they can get their own green card as well. I hope this answers your question. If you are in a similar situation and you are still not clear on what I just explained, feel free to contact me. My information, as always, will be in the description below. So question number 2. Question is, can I file taxes with the category married filing separately because my wife has no income and she's not able to file taxes? We're planning on filing a petition for her green card through marriage. Will that affect us in any way? So this is a great question because this person wants to know whether the USCIS will still consider their marriage to be real if the couple does not file taxes together. Now, I'm not a tax expert, but I know that if you're married, you're required to file married filing jointly or married filing separately. In this scenario, for immigration purposes, I encourage my clients to file married filing jointly for the reason, in order to use the tax document to prove that your marriage is real and not just for immigration benefits. In certain circumstances, this is not possible. So people file married filing separately because of other financial reasons. You have to talk to a tax specialist about that. So if that's the case and they file married filing separately, I think that for immigration purposes, it will still count as a joint document because it's still going to have your spouse's name on there, just, that you're filing separately, whether because she doesn't have income or they have other tax issues or just whatever reason they're filing separately. But for immigration purposes, the tax document that you generate from filing, from married filing separately, still shows that you're married, which is the main point for tax transcripts in immigration. Okay, so other than the fact that filing taxes shows that you're a good citizen and also helps with immigration, it's solely used to prove that a couple is bona fide. Oh, and also, well, for the public charge rule, which is a different thing, which I'm going to go into later, your taxes come into play there because I want to see how much you're making to see whether the intended immigrant will become a public charge in the future, that is, receive public benefits. Anyway, I'll move on to question number 3. As you're watching this, if more questions are popping up in your head as you're listening to the answers, feel free to put that in the comments. I will read them and answer them next Friday in my 4 questions Friday. Okay, this one is a deep question, so listen, it has different layers in it. All right, so the question is, I have a DUI homicide case on my record. Can I apply as a petitioner to have my fiance come and marry me on a K-1 visa? I was 17 years old when it happened. Excuse me. My sentence was 5 years prison time and 5 years extended supervision. I'm 32 now, and that's the only blemish on my record. So will this affect the application? So I can understand why this person is asking this question. This is clearly a U.S. citizen who is in love with someone who's outside of the U.S. and they hope to apply for a visa, a K-1 fiance visa for the person to come into the U.S. so they can get married and then the person can obtain a green card. So it's definitely a lot of government process, and usually when you have things like a felony on your record, it prevents you from doing several things like voting, for example. That's something I learned recently, that felons can't even vote. So I can understand the concern with this question. So my answer goes like this. If a petitioner, a U.S. citizen, has a record, a criminal record, it does not directly affect your ability to petition for your fiance or spouse or any other family member who wishes to come into the U.S. through you. The real issue, the time when criminal activity is going to come into play is if the intended immigrant has a criminal record. That's going to be really serious as to whether the immigrant can even qualify for the immigration benefit. So if the intended immigrant has a DUI on their record, or what was it you said here? DUI homicide. That's pretty serious for an intended immigrant. But for the petitioning U.S. citizen, if you have served your time, like you said you have, and you have paid your debt to society, your past criminal records will not affect your ability to petition for an incoming immigrant. Okay, so it's a great question. It's really something, I mean, you probably have to disclose if asked, but it does not, it's not being considered as far as whether the immigrant is able to come in. The issue is whether the relationship you have with the immigrant is real and not just for immigration benefits. So that's the issue. And then, like I said, we'll think about the public charge, because that's something that comes up whenever someone is adjusting status to green card holder. All right, I'm on my last question. for today. It's been amazing answering these questions for you guys. I can't wait to do the next one for next Friday. So subscribe, hit the notification bell so you can get notified when I post that video. All right. Question number 4. This is a great one, also about green card and marriage. This question comes up a lot because marriage is one of the ways to obtain your immigration status, like a green card, and then to U.S. citizenship. So I see a lot of these questions because people want to make sure they're doing things right. That's great that you ask a lawyer, because a lawyer has experience dealing with several clients, going through the same thing, so they can give you advice based on that. Anyway, so here's the 4th question. Can an undocumented immigrant get married to a green card holder? And that was just a question. I was like, yes. If the question is whether the green card holder can help you adjust your status, of course. A relative of a green card holder and a U.S. citizen can adjust their status to green card holder. Even though, the only difference is that when you are the relative of a U.S. citizen, the timing might be different when you're a relative of a green card holder. So sometimes people like to wait until the green card holder attains citizenship, and then at that time then apply for benefits for their incoming immigrant. People do that sometimes just because of the timing differences. But yeah, non-immigrant, if you come into the country, you meet a green card holder, you fall in love, and it's real. There's no rules preventing people from marrying anyone. Just make sure that, you know the person. Obviously, you're not marrying like a stranger. So if you already know the person and your marriage is real, there's nothing stopping you from getting married, and then your green card holder spouse can obviously file the I-130 paperwork and help you adjust your status. So it's that simple. Yeah, so 4 question Friday. I answered 4 immigration questions. I'll be happy to see your response to this, to see your comments, to see other questions that I can answer publicly. If you want to be anonymous, you can send it anonymously. I won't, I'm not saying names right now anyway, so you don't have to worry about that. Just send me your questions. I'll be happy to answer them on my channel. Again, my name is Ify, immigration attorney, and you're watching Immigration Success with Ify. Have a great day, and see you later. Bye.